Okay, Mr. Lobello, are you able to hear me okay?
Yes, Your Honor.
We've got a record in Crystal Gantz versus William Smith, file number 2511839. Mr. Isles, you representing plaintiff, is that correct?
That's correct, Your Honor.
Present here in the courtroom, we have Mr. Lobello, you're representing the defendant, Mr. Smith.
That's correct, Your Honor.
Okay, Mr. Lobello is present by Zoom video. This is set for a scheduling conference here today. Mr. Alves, can you just kind of tell me what your claims are about in this case and what you'd like to see for scheduling going forward?
Your Honor, this is a wrongful death case, car accident, single car accident. The defendant is the husband of the decedent. My client is the daughter of the decedent, not his stepdaughter. Out on 75, headed down the road, spun out, bounced off of a guardrail out in front of a truck, broke her spinal cord and killed her. And police report says he was driving too fast for conditions and he left from here in Frederick to get down there. So he was on the road. But that's pretty much it. I don't see any reason to oppose him. I don't believe I'll need an expert witness 2 days for this thing. But I know that Mr. Lobello has to do his due diligence, and whatever he really needs to do for to prepare for trial is fine with me. I'll be ready to go whenever.
Okay, Mr. Lobello, in terms of scheduling, what would you like going forward for discovery and so forth?
Your Honor, as brother counsel pointed out, there is some records that we need to obtain and obviously diligence that we need to do. Most specifically, medical records. And I guess to shorten things down, we would be looking for 150 days of discovery with facilitation ordered by the court, perhaps at the end of discovery.
Okay. Any objection to that time frame, Mr. Isles?
No, Your Honor, that's fine.
Okay.
I used to do Mr. Lobello's job. I understand the need to do your due diligence. So yeah, 150 days is fine.
All right, so we'll set aside 150 days for discovery. The court will order that mediation be completed within 30 days of the end of discovery. The court will set this for a dispositive motion cutoff at that same period. So about 6 months out will be motion for summary disposition cutoff. And then we'll set this for a status conference. I typically don't set trial dates at the initial scheduling conference. I set a period for discovery, mediation cutoff, and then dispositive motion cutoff. Then to the extent that the case hasn't resolved either by motion or settlement, we'll have that status conference and we can discuss going forward towards trial. Mr. Isles, from your side, is there any need to amend any pleadings or add any parties?
Not at this time.
Okay, Mr. Lobello, do you need to bring anybody else in, or are we all set with that?
Not at this time, Your Honor.
Okay. So, Mr. Isles, do you believe that you and Mr. Lobello will be able to agree on a mediator in this case?
I don't see why not.
Okay, Mr. Lobello, do you think that'll be an issue?
I don't think so, Your Honor.
So I'll just put in the pretrial order, the parties are to confer and agree on a mediator and notify the court of your selection within 30 days. And then I will send out a scheduling order that reflects all of these dates. Mr. Isles, anything else I can address for your side for scheduling?
No, Your Honor, thank you.
Mr. Lobello, anything further I can address for your side for scheduling?
Nothing from our end, Your Honor.
Okay, so along with the scheduling order, the court will also send out notice of the date and time for that next status conference at the close of discovery. And Mr. Lobello, you're free to disconnect. Mr. Isles.
Thank you. Have a good day.
Thank you, Your Honor.
Okay, looks like we have the parties connected in Colin versus Colin. So we'll go on the record in that file. That is file number 2411622. Mr. Vernon is connected along with his client. I see Mr. Colin is also connected. Again, Ms. Lee present here in the courtroom today in front of the court. And fire. What, do you know what this hearing is?
Yes, Your Honor. Front of the court has filed this motion.
So it's got a lot of background noise that I'm not able to hear. I'm just gonna mute you guys for right now. Okay, go ahead.
Okay, Your Honor. Front of the court filed a motion. Let's see, what date did we file this? March 20th. We wanted to address what was stated on the record at the de novo hearing on February 12th. There was an objection to a referee recommendation, and it's front of the court's understanding that there were two modifications to the referee recommendation. And then one was that Mr. DeFranco would not be present for child exchanges, and two, on a temporary basis, defendant's parenting time was to be suspended until allegations through either the Child Advocacy Center or CPS could be substantiated or not. Front of the court has received a parenting time violation, but under the order from back with Your Honor at the de novo hearing, it's our understanding that Mr. Collins' parenting time is suspended until further notice. And so we would like to have further clarification from the court that that still is in effect.
So I'm going to address that with the parties in a second. I believe, and I'm sure one or both of the parties will jump in. I believe that violation was based on things that occurred prior to that de novo hearing date, and alleged violations by Miss Collin prior to the suspension of the parenting time.
Okay, let me see.
Because we did ask, Mr. Collin asked about that violation and when it was set for hearing.
Yes, it was the previous Friday.
Yeah, it had been filed prior to the date that we had that hearing.
Because this was filed March 19th and our hearing was on February 12th.
Yeah.
Okay.
So in my view, the suspension of the parenting time shouldn't have anything to do with the alleged violation.
Okay, because he does have some dates in here. His handwriting is hard to read. March 5th, Wednesday, March 12th, Wednesday, I can't read the date for March. So there are a couple of March dates in here.
Mhm.
So I guess.
Be the whole
So
month.
Hold on a second, Mr. Collin.
Okay.
For the dates prior to March 5th, that suspension was not in effect. However, the dates after March 12th or February 12th are in effect for the suspension, correct? Okay,
Yeah.
that's what I needed to know.
Okay. Does that clarify?
Yes, it does, Your Honor.
Okay. All right. I do have a question. Has there been, Mr. Collin, has there been any resolution of the complaint that was made that we discussed last time?
I believe that there's no, I mean, they tried to contact me yesterday, but to go over, not going to court today, but that didn't, I didn't want to do that because it clearly shows that they were, just trying to, keep my kids away from me for another month for whatever reason. Because they could have done that a month ago before I had to file the parenting time complaint for this issue. But obviously nothing came about the evaluation with my son CJ, and like I said, CPS came to my house and they dropped the case and should be reinstated. It didn't have to go to this point. They could have simply done it after the evaluation because there was anything after that point. So for a whole month, they delayed it. And if I wouldn't have filed the paperwork, then the court wouldn't have administered this date. And then Vernon decided that they had to try to offer me something to agree to before this court date, because then it would look like they were trying to keep my kids away from me for parental alienation. And I didn't want that. And I wanted to go in front of the court because of this, because they could have implemented it a month ago.
Okay,
So
I don't know that you answered my question.
What was it again, Your Honor?
Has the CPS investigation been concluded or not?
Yeah, that's what I said. Yeah, they said that they came to my house and that was done on 30 days
Okay.
would have been March 10th.
You give me all of this extraneous information, it's hard for me to figure out exactly what you're talking about. So
March
the
10th would have
CPS
been,
came and they did an interview with you. Did they interview the child?
I am not aware of that because they weren't at my house. I have no information on the any of the documents for the alleged case, besides the fact that CPS specifically stated to me when they were at my house that the case would be dropped and that March 10th was the final day for that because they have to have 30 days.
Okay, all right. Mr. Vernon, is there anything you'd like to add to the discussion here in terms of where the status of the CPS investigation is? You're muted. Mr. Cowan, I can handle addressing everybody, okay? I don't need you to jump in.
Okay.
So please don't jump in unless I ask you to give some input.
Okay.
It was you who muted us. We weren't sure if we could unmute or not. So with regards to the prior parenting time issue, that was a January 8th date. So I would agree with the court that took place prior to the court temporary suspension. With regards to the current temporary suspension of parenting time, the child was taken to the Child's Assessment Center. They did an interview. They determined that there was insufficient evidence to do any further investigations. So they closed that matter. At the last hearing in front of the court, I raised this issue. This was at the hearing on Mr. Collins' parenting time violation. I raised the issue of whether parenting time ought to be reinstated, questioning whether the court's prior order temporarily suspending Mr. Collins' parenting time was self-effectuating or whether further court hearings had to be done to reinstate that parenting time. The referee identified that she was unclear because there was not a written order in the file for her to reference. Then the friend of the court scheduled this hearing. So we had a conversation with Mr. Collins yesterday in an effort to write down and stipulate to the offer we actually made at the referee hearing, reinstating his parenting time, that he refused then. So the suggestion that we're stalling is patently untrue because we offered that parenting time on an issue we raised, trying to give him that parenting time. In fact, what we were trying to do is increase his parenting time. And the referee will show that we were trying to increase his parenting time on Wednesdays by 2 hours across the board, irrespective of whether there was a parenting time violation or not. So we drafted a proposal to increase his parenting time on Wednesdays by 2 hours and his parenting time on Saturday by 2 hours in an effort to make up any lost parenting time due to the court's temporary suspension of his parenting time. And we sent that over to him, and after having a conversation with me that he said he agreed to it, he then refused. So we're here, but our proposal would be that we extend his parenting time on Wednesdays by 2 hours, that we extend his parenting time on Saturday by 2 hours, and that the court order that the temporary suspension be rescinded, reinstating that previous parenting time with the increase that we've just identified to make up for his lost parenting time. What we identified was an increase in parenting time from 10 to 6 on Saturday to 9 to 7, adding 2 hours on his Saturdays, and then increasing his parenting time by 2 hours on Wednesday, which was originally from 4 to 6, increasing that to 4 hours and making it from 2 to 6 p.m. So that's where we are on this. I think we've been more than accommodating and certainly trying to get Mr. Collins' parenting time back as quickly as possible, despite his refusals to enter into those orders and accept those terms.
Okay, so Mr. Collin, essentially you have two choices. Number one, the court's gonna rescind that prior order because I find there's no reason for that to remain in place, given that the CPS investigation was not substantiated. So you have two choices in terms of makeup parenting time. You can go with what Mr. Vernon is suggesting, or we can set it for a hearing in front of the referee, and the referee will decide how to determine the makeup parenting time. So how do you want to proceed?
Yeah, I'd like to proceed with going in front of the referee because Mr. Vernon did say that he stated that he was trying to come out of their way or whatever to accommodate me for getting my parenting time back. But as well, like I stated, they waited till the last day in a sense. And he was doing that to have us not have to go to court today. So he knew that we didn't have to go to court to, as long as we can agree, we would have not had court today. So we could have done this a month ago. But like I said, and there's other stipulations too, like Wednesdays, it's not easy. That's very
Okay,
difficult.
I don't need to, I just need to know how you want to proceed. So you want to go forward with the hearing before the referee?
Yes, Your Honor.
Okay, all right, so that's how we'll proceed. The court will rescind the suspension of the parenting time, so that will, the prior order will resume, and then the referee will have to determine the makeup time issue.
Yeah, sure.
So, okay,
Thank you.
all right, thank you, that's all I have for this hearing today. All parties are free to disconnect at this time.
Your Honor, just so we're clear, then the Wednesday parenting time will continue to be 2 hours from 4 to 6, and Saturday will continue to be parenting time from 10 to 6.
The first one will be
Whatever
for
the prior order was, I don't have it in front of me,
Your
but
Honor.
Thank you, Your Honor.
Your Honor.
Yeah.
We did verify that with the last parenting time complaint violation that my first Wednesday upon reinstatement of my children, that the first Wednesday will be 2 to 6 because of making up those other 2 hours that I had gotten back. So the first Wednesday, I got the document today from that referee's hearing that the 2 hours will be on the first day, the first Wednesday, which will be 2 to 6 on the first one. And then from there on will be just the 2 hours.
All right, yeah, whatever the referee has put in the order, that's what we'll
Yep.
follow, so.
Yep. So the first Wednesday is 2 to 6, and then the rest are 2 hours for now.
I don't know, I don't have it in front of me, but whatever it says, that's what the parties will follow, okay?
Okay, that's what it says. I got it today.
Okay, all right, very good. Okay, thank you, that's all for today. The parties on this file are free to disconnect at this time.
Thank you, Judge.
Thank you.
On my desk is some papers. There's the motion that that's filed.
Yeah. Yeah.
All right, we'll go on the record in Godiva versus Ruttkamp. This is file number 2411707. If I could have both counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. Elliot Blumberg on behalf of Brooke Godiva, who is appearing via Zoom from my office.
Good afternoon, Your Honor. Miranda Bailey Quick on behalf of James Ruttkamp. I am present via Zoom, and Mr. Ruttkamp as well as Cynthia Elkhorn are present in the same conference room at the bottom of the basement of the courthouse with me.
All right, thank you. We're on the record here today. Ms. Bailey Quick, you filed a motion for exclusive possession of disputed premises. I did have a chance to review your motion as well as Mr. Blumberg's response. Ms. Bailey Quick, anything by way of oral argument that you'd like to raise here today?
I did have an opportunity to review Mr. Blumberg's motion and response. I do believe, if the court wants me to brief it, I unfortunately did not have, I did research the issue. I do believe that the statutes as well as court rules contained in my motion comply if the court wants a separate brief. There's nothing required in the court rules themselves that require a separate document per se of a brief, but if the court would like that, I'm happy to do that. I would just like to note that I did have an error as to the address of the property. It is 4844, not 4484. And so I just wanted to point that out as well. Additionally, the sum and substance is that there's repeated statements throughout Mr. Blumberg's response and his brief that essentially Mr. Ruttkamp and Miss Elkhorn are preventing Miss Godiva from accessing or coming to the property. And that's just frankly not the case. I think the court probably has sufficient information at this point related to the history and the parties that it is Miss Godiva's actions on her own behalf that have prevented her from accessing the property or being allowed at the property. There is multiple personal protection orders. There's been criminal actions. It's her actions alone that have prevented her from being allowed at the property. And so, yes, although I acknowledge that the parties are joint tenants in common, and by definition, they are both entitled to full access of the entirety of the property. If we were talking about individuals that didn't have any other barriers like personal protection orders or in the past criminal bonds or other issues. However, that's not what we're dealing with. What we are dealing with is individuals that have other barriers. And the continuous litigation created could be alleviated with an order until this case is resolved. We need some resolution. These parties cannot and will not be able to live harmoniously at this property. One party will have to ultimately buy out the other property. And this is the only place that the minor child has ever resided. And that's ultimately what's before the court. And we are just asking until this case is concluded to essentially grant exclusive use to my client, given the very contentious and litigious actions, and that would hopefully put to bay involvement of multiple other courts involved, so that we can get a resolution, whether that's soon, hopefully, that we can finalize this case, or whether it's 3 months from now or whenever that is. But this would, I think, help give some finality and an assurance to everybody involved, and reduce the number of additional litigations being involved.
Thank you, Mr. Blumberg.
Well, Judge, I think, again, I apologize for the late filing of our response to this motion, but the court, as you know, in Gaylord, we were out without power for a significant period of time. So if we were in front of Judge Burmeister earlier today on the eviction proceeding against Miss Elkhorn. Miss Elkhorn is a resident of this property as a guest of Mr. Ruttkamp. She is not a tenant. She has no legal right to be there. Consequently, my client has been prevented from entering this property since 2022, when this fraudulent lease was prepared by Mr. Ruttkamp, which effectively kept my client out based on a PPO that Miss Elkhorn had obtained against Miss Godiva. Mr. Rutkamp is the recipient of a PPO. He can't be in the same proximity with my client for almost 2 years based on Judge Burmeister's ruling. So yeah, there is a high level of contention between the parties, but contrary to counsel's representations, this wasn't all brought on by my client. It's by the duplicitous actions of Mr. Rutkamp. Once Miss Elkhorn is evicted by virtue of the district court, then my client will have access to that property. The PPO that Connor has expired. There is no PPO in place between the child and the child's mother. There is a custody proceeding moving along in Judge Burmeister's court. So this motion is so ill-conceived and based on no legal authority. I mean, there is reference to a temporary injunction, and yet the pleading doesn't even state what the court is required to go through in determining whether a preliminary injunction is appropriate. I have asked the court to not even hear this motion because the court rule clearly requires whenever there is an issue of law that's presented before the court, it is required that a brief be filed. I don't believe under any reading of this motion could the court consider this to be a brief. You are given no guidance as to the authority for the relief that you're being asked to grant in this case. We are asking the court to deny this motion. Once Miss Elkhorn is evicted from the property, then my client will have access to the property that she owns. Part of this lawsuit, Judge, is a claim for ouster. My client, an action that we originally brought in the district court that Judge Burmeister removed or told us we had to bring in circuit court. Ouster is a claim where one joint tenant takes actions to cause the removal of another co-tenant unjustly or without any legal authority. And that's what's before the court. It's not just this partition action that was an afterthought filed as a counter complaint in this case. Again, I don't believe that there's any authority for the relief that you're being asked to grant in this case. And candidly, I take exception to the manner in which this matter was brought before the court without any authority for the relief, with no brief filed, no affidavit. It's an unverified motion. We just think that it's improper for the court to grant this. We would ask the court to deny the motion, allow the eviction process to continue in district court, and then we'll continue to litigate this matter to its conclusion before you. Thank you.
Where is the eviction process at, Mr. Blumberg?
Well, as of this morning, I was certainly of the impression, because Miss Bailey Quick asked the court for additional time, which I happily offered her, because in the eviction proceeding, Mr. Rutkamp and Miss Elkhorn are claiming that she is a tenant, a holdover tenant. There was a lease that expired, and she continues to reside there. By her own admission, Miss Elkhorn's own admission, and Mr. Rutkamp's signed pleading, they both acknowledge she is a guest. And as a guest, she has no legal entitlement to be in that property. And I think Judge Burmeister candidly is going to find the same way. It's my feeling that she will be evicted fairly soon.
Judge, may I respond?
Yeah. Yep.
So I had filed a motion for summary disposition in the eviction proceeding, and I received a response yesterday, which is why I was given additional time to be able to review that with my client as well as respond to that. Contrary to Mr. Blumberg's position, I believe that Judge Burmeister has no option other than to dismiss the eviction proceeding because it was improper. Notice was improper, and whether Miss Elkhorn was a prior tenant, yes, she has stated that she has remained on the property as a guest. However, she pays for certain items. She care takes at the house. She does certain item or certain things. And by virtue of all of that, she is a tenant by conduct. And that requires a 30-day notice to quit, which was not afforded. And that is the opportunity in which I get a chance to respond to. And so I believe, based on all of the law, again, and the improper notice, that that Judge Burmeister is likely going to dismiss the eviction proceeding.
Well, do you
Again,
guys have a next hearing date in front of Judge Burmeister, or what is?
no, he gave me 7 days to review the response and file my reply brief.
And then he's gonna issue a written opinion, is that, I'm just trying to get a sense of the procedural posture of that case.
Right. Yes. He said he would issue either a written opinion or bring us back for hearing.
Okay,
That's correct.
okay.
Your Honor, there was statements made that there was a lease in 2022 for Miss Elkhorn, which is not the case. And that it was something done by Mr. Ruttkamp alone, which is again is not the case. And that it was only because of that Miss Godiva hasn't been allowed at the property, which is again also not the case. And it is my understanding that there is a motion to extend Connor's personal protection order in Otsego County. I'm not involved in that. I don't know the status of that. That's just what was brought to my attention. So that may continue prohibiting Miss Godiva from entry on the property. Initially, she was barred from the property because of criminal proceedings that both of the parties were facing. It wasn't because of Miss Elkhorn. It was Miss Godiva and Mr. Ruttkamp. Both of them were prohibited from being at the property. She then agreed for Mr. Ruttkamp to go back to the property. And so, I just want the court to be aware that several of those statements were just not accurate.
All right.
Judge, I don't know if
Well, I just have a question, Mr. Blumberg. Is it fair to say that as long as Ms. Alcorn has not been evicted from that property, that your client is prohibited from going there based on the PPO?
Yes.
Okay. So I think there's a number of issues here. I think, first of all, I tend to agree with Mr. Blumberg, especially if the request is for some type of injunctive relief to prevent Ms. Godiva from accessing the property. That's an extraordinary relief, as the parties are aware, and I think it would have to be, any request in that regard would have to be in strict compliance with the court rules governing injunctions. And Ms. Bailey Quick's motion clearly does not comply with the requirements under the court rule for injunctive relief. And I kind of took Ms. Bailey Quick as your motion as kind of a mixed injunction, invoking the court's equitable powers to maintain the status quo, so forth. But it was less than clear. And I think if the court is going to prohibit a party who otherwise, outside of the PPO, as you said, and outside of any other circumstance, would have a legal right to be on that property and access it, I think I would need a much more clear basis for which you were requesting the court to order her to not have access to it. In addition, as Mr. Blumberg just acknowledged, and I think both parties recognize, is as long as Ms. Alcorn has not been evicted from that property, Ms. Godiva can't access it without violating the PPO anyway, which I'm sure counsel has advised her not to do. So the court finds that even if I was looking at this from the standpoint of an injunction, there isn't that kind of immediate or imminent threat of a problem here that the court would have to find, because there are other orders preventing Ms. Godiva from accessing that property. So I think two things would need to happen, Ms. Bailey Quick, before I can grant the relief you're requesting. First, I think it would have to be more fully briefed and supported by affidavit. And I think there would have to be a clear statement of what powers you were invoking the court to exercise. And then Mr. Plumber, of course, would have an opportunity to respond. And I think we would have to have a situation where there wasn't any other prohibition from Ms. Godiva from accessing the property if the request is made as an injunction, because again, I think there would be an issue with the immediate, imminent, and irreparable harm element, which is arguably the most important element of an injunction. That doesn't mean that there aren't other, there wouldn't be another basis such as status quo or maintaining peace or something like that, maybe that some other type of mechanism that you could invoke the court's equitable powers to exercise outside of an injunction. But either way, I don't think I'm in a position to be able to grant that relief as it's been presented. So the court's going to deny the motion without prejudice. And Ms. Bailey Quick, you're free to refile at such time as Ms. Alcorn is evicted and the PPO is not going to prevent Ms. Godiva from accessing the property, or you have a clear statement of the basis for the court exercising its equitable powers. So Ms. Bailey Quick, if you can prepare an order that reflects the ruling of the court today and submit that under the 7-day rule. And then we'll see where we go from here. That's all I have for today. Both counsel are free to disconnect at this time.
Thank you.
Thank you.
Mr. Mamet, are you there?
Yes, good afternoon, Judge.
Okay, are you signing in on the NCACU versus Robert Moore case?
Yes.
Okay, this is Mr. Mamet, this is your motion for summary, I'm sorry, a default entry of a default judgment in this case. I did have a chance to review your motion. It does appear that the defendant was properly served with the summons and complaint. There has been no answer or otherwise any defense to this case. This matter was set for hearing at 2 o'clock. It's now 2:13. No one here on behalf of you're not Mr. Orr, are you, sir?
No, sir.
Okay. No one here on behalf of Mr. Orr has appeared. Is there anything that you wanted to state in support of your motion for default judgment, Mr. Mamet?
Yes, Your Honor, briefly, just to complete the record, suit was filed October 7th, 2024. The court granted alternate service and a second summons. The defendant was served via certified and first class mail on February 3rd, tacking on February 5th at the address of this court, verified via postal through our process server. Plaintiff's motion was served on the defendant on March 28th at that same address. Again, the postal at 615, or the address on 615. So at this point, plaintiff would just ask that this motion be granted.
Okay, based on the failure of Mr. Orr to defend or appear today, the court will enter the default judgment. I've signed the proposed order that you presented with today's date. Is there anything else that I can address for you today, Mr. Mamet?
Not from plaintiff, Judge.
Okay, thank you. You're free to disconnect.
All right, thank you. Have a great day.
on the record in Copper versus Patricino. This is file number 23-11369. Yeah, Mr. Thompson, you're here on behalf of your client. Ms. Copernall, Ms. Patricino is here on your own behalf. Mr. Thompson, what do we need to address here today?
Well, unfortunately, before the ice storm, there was some very significant roof damage leaking at the property. And Ms. Patricino refused to allow repairs, and that prevents the property from being sold as the court has ordered multiple times. And this time delay, you know, this is a 23 case. There was a settlement last year. It was supposed to all be taken care of by October. Obviously now it's April 2025. The fact this is not resolved, you know, problems like an entire room flooding out can happen, and it has happened. Leaves my client, again, without the property being sold as the court has ordered so many times. And she's just without any kind of recourse. Defendant is refusing to allow repairs, refusing to allow access. The problem of the snow on the roof, obviously there's not snow on the roof at this point, but we believe there's significant damage to the property, and that's going to prevent any sale at this point. We provided photographs with our motion that show those, and I'm able to hear as a witness if we need to have an evidentiary hearing.
Ms. Patricino?
Yes, Your Honor. There was an ice dam happened on the second week of February. That was February 14. I reported that to the realtor right away. And I was able to fix it. Finally paid roofers, professional roofers, and cost me $400 plus materials. And then I called my State Farm right away on Monday regarding the issue of the ice dam damage that collapsed the ceiling of my kitchen. And they told me that it is not covered with the roof repairs, but they can do the ceiling repairs. So I forwarded that message to the realtor. And at that time, I don't have money to repair for the roof repairs because they said it's not covered. But I've been pursuing the State Farm. I was able to file a claim on the 25th. And been dealing that whole month. And I was able to find contractors to repair for the roof repairs and also the inside. The adjuster State Farms came in to see the damage, and they did pay me a check to get those repairs. So I've been dealing with that, and the repairs will start on Saturday.
Is this information that you were aware of?
No.
What I'd like to do is just take a short break. Mr. Thompson, I'd like you and Ms. Patricino to have a conversation so that you both can understand where this is at now in terms of repairs, damage, and so forth. I want to see if that can result in some kind of agreement as to how we're going to go forward. If it doesn't, then I may have you back into the courtroom. Take some testimony, go forward that way. But I'd like the two of you to have a discussion so that Mr. Thompson, you're fully aware of exactly what's happening on the property now. Let's go back on the record in maybe 10 or 15 minutes.
We have that conversation here, Your
we're back on the record. Mr. Thompson.
We made some progress, Shannon. We don't have an agreement on the financial issue about, distribution of sales proceeds someday. I do believe we have an agreement from the defendant that she will allow showings with 24-hour notice, that the realtor can come to the property on Tuesday around 6, and that Ms. Coppernall is an additional insured on the property, and if she's not on the home insurance right now, she needs to be added. My client's got significant concerns. It sounds like there was an insurance payment for this damage. It sounds like it was made out to Miss Patricino, and she has it. She got a check for a neighborhood of $9,000. Miss Patricino tells me she's made arrangements for contractors to come out and do work that's going to begin this weekend and hopefully be completed shortly. That hasn't happened, the work hasn't happened yet, so I'm not in a position to know whether that's happened or not. It would be my hope that that would happen and that the property would get sold next week. But there's still a lot of issues between the parties. And obviously, I know Miss Patricino's attorney passed away, which was tragic. But my client's got some very significant concerns here about the insurance check for $9,000 that's sitting out there, about this work that needs to be done, and ultimately about just, who's been paying the mortgage. And I understand the court isn't going to resolve all of that today, but that's where we're coming from.
Okay. Ms. Patricino, in terms of the agreements for the things that Mr. Thompson indicated, is that correct? Do you agree with those terms?
Yes, and the contractor will come in this weekend to get the job done.
Okay.
Yeah.
So I guess what I'd like to do, Mr. Thompson, is have this set for hearing on the court's next available date. Because I do want to keep track of how this is going. This has been going on way too long as it is. And I want to make sure that it continues to move forward towards a final resolution. I think court intervention is the best way to make sure that that happens. So you don't have to file a notice of hearing, Mr. Thompson. I'm going to have Jennifer set this for.
Can we ask her to give us a little more time on this next one?
How much?
I would like an hour, and I'll be prepared with witnesses and exhibits. And I would just ask the court to instruct Ms. Patricino that if she wants an attorney, she should have one there, and not adjourn on that basis at that hearing.
Okay. So Ms. Patricino, I mean, you understand that it's to your benefit to have an attorney who can adequately present your side of the case and represent you here.
Yeah, I think
Oh, and sir, I don't know who you are.
I'm sorry.
If you're not a lawyer, I'm having you sit there as a courtesy to Ms. Patricino to be there as support for her, but I can't have you speak on her behalf. So Ms. Patricino, do you understand that an attorney would be likely very helpful to you in terms of presenting your side of what's going on here?
Okay.
Do you understand that?
Mm-hmm.
Okay. So I'm telling you right now, I'm not going to adjourn things because you're asking for more time to get an attorney. You're going to get another lawyer. Now is the time to do that. Okay.
you need to have an attorney and you need to ask when the next hearing will be.
I'll do my best to contact an attorney, but I don't know if I can't control who's going to be available to represent me.
Yeah, I understand. I just
Yeah.
want you to be clear that I'm not going to put things off to give
Okay.
you more time to do that.
Okay.
Okay.
Thank you.
I'll prepare an order to that effect. Thank you.
Thank you. That's all.
Thank you, Your Honor.
Okay, counsel, I apologize for the delay there. I had another matter that went a little bit longer than I anticipated, so we are a few minutes behind, but I do want to go on the record now in Sarah versus Sarah. This is file number 2311355. If I can have both counsel put your appearances on, starting with plaintiff.
Aaron Byrne on behalf of Mrs. Sarah, who's present seated to my right.
Michael Cutler on behalf of Stephen Sarah, who is on screen.
Okay, we're set for two matters in this case today. Number one, the first thing I'd like to address is plaintiff's motion regarding alleged failure of defendant to comply with the court's ruling. And then we have Mr. Cutler, defendant's objection to the proposed judgment of divorce drafted by Mr. Vernon. So Mr. Vernon, addressing your client's issue first, my understanding based on the written submissions is that your client's motion is based on the failure of Mr. Sarah to make payments.
Yes,
as
you're
required.
I did not participate in the drafting of that document. Mrs. Sarah did that of her own accord. My understanding is that Mr. Sarah has failed to make payments on the vehicle. The March payment has not been made. The April payment is due. That has not yet been made. And the, was it the car?
Support the insurance.
Oh, and then this, yeah, and then there's the support that hasn't been paid.
And the pension.
Right, when I say the support, I mean, I suppose I mean the pension as well, but so none of those payments have been made. In court order states fairly clearly that Mr. Sarah was intended to make those whether this order was entered or not, or at least until it was entered. And because counsel objected, we have not yet had an order entered until probably today. Mr. Sarah would be responsible for making those payments.
All right, thank you, Mr. Cutler.
Thank you, Your Honor. As far as the pension, that topic first, the pension is not paid for my gentleman. It is through the pension agency. The pension payment was requested and it was submitted. Our understanding confirmation from Mr. Sarah is that the 1/2 portion of the pension was paid on March 29th. They do it automatically every month. As far as the payment of the $1,000, we did not have any address for Ms. Sarah. I contacted opposing counsel. Eventually, I got a response from him within 4 days of getting that response. My client submitted a cashier's payment in the amount of $1,000 to the P.O. box that was provided to us. As far as the car and the insurance, the order of the court, the opinion of the order of the court was that both parties were to engage in certain activities relating to the vehicle. Ms. Sarah was to transfer the title and transfer the obligation to her name. Apparently, she has not undertaken any steps in that regard.
Okay. All right, so the court is going to order that the pension payments, well, first of all, can we, Mr. Vernon, can we put on the record here today an address for Ms. Sarah that the payment should be sent to?
It's P.O. Box 147, Grayling, Michigan, 49738.
I'm sorry, can we have that lower? I was writing it down, Your Honor.
P.O. Box 147, Grayling, Michigan, 49738.
Thank you.
Okay, so the court's going to order that the March and April payments as provided in the court's opinion in order be made within the next 14 days and sent to that address. With regard to the vehicle, those obligations, in my view, would not arise, unlike the payment of the pension and support, which the court expressly provided for in the opinion and order. The other provisions, such as the vehicle, would be effective at the time that the judgment of divorce is entered. So I don't find that Ms. Sarah's obligation has arisen until that judgment has been entered, which I suspect we're going to be able to resolve here as the next matter today. So I am going to order that Mr. Sarah make the March payment as to that vehicle, as he has been making all along. And then that, assuming we address the issue with the judgment of divorce, then once that's entered, then that obligation will transfer to Ms. Sarah, along with the obligation to refinance that vehicle and remove Mr. Sarah's name from it. So that's how we'll handle those two issues. With regard to moving on to the next subject of the motion, which is Mr. Cutler, your motion regarding the judgment of divorce, I did review your filing. Is there anything that you wanted to state in that regard today?
No, Your Honor, I think I highlighted, I requested drafts of the judgment, so we didn't have to have this delay. Unfortunately, I never received the draft. I never received what I had hoped to be cooperation to review the language to address these. I think I have three requested, actually 2 changes, 1 omission, and then 2 grammatical errors, which include provision that I don't think the court ordered. So it's really 5 issues in total. Unfortunately, we're delayed to today's date, but I do want to have those addressed. And I think I expressed them to the court unless the court had any specific question of me.
I don't. Thank you. Mr. Vernon?
So I'll take them one at a time. With regards to the language that Mr. Cutler proposed for the vehicle that states that plaintiff will be required to remove the defendant's name from the title and that, I think that's consistent with the court's instructions, so I have no objection to that language. The student loan, we did refer to it as the Parents Plus, and the court did refer to it as student loans. I have no objection to that. There is a request in the in Mr. Cutler's answer to the show cause, suggesting that my client is responsible for 1/2 of the monthly payments. I would disagree with that, and that the language in the order that the court drafted simply said that the debt is divided equally, not the monthly payment structure is divided equally. So I think that is an inappropriate language. So the proposed language that is in there with regard to the student loan, that states that the student loan debt, including any Parents Plus loans made by the parties during their marriage, is to be divided equally between the parties. I don't have any objection to that language. With regards to the attorney's fees, again, that's fine. I don't have any problem with that language being added. I think the typos that he pointed out are accurate, should be corrected. The only other thing I would add is that the Michigan Court Rule 2.602 subsection B3C identifies that the party filing the objection, that would be Mr. Cutler, must serve on the parties all of the objections together with a notice of hearing in an alternative proposed judgment or order. Mr. Cutler did not do that. He included the proposed language in his motion, but we do not have a proposed alternate order. So the suggestion that I have to make those changes to the order, I believe, is inconsistently placed, consistent with the court rule, and that is something that Mr. Cutler would have to draft and submit.
May I address that, Your Honor?
Yes.
Thank you. Once again, if counsel responded to my request and I sent 3 or 4 requests for the draft, then I could have obviously included some of these changes. For whatever reason, I received no cooperation, and I've adhered to the court's opinion stating that objections would need to be filed as opposed to an objection with a separate motion was pursuant to the court's order. Counsel has the language. The changes are minor, so I'd ask that he make those changes in light of the history of our relationship up to this point. I would like to make one inquiry of the court. The court specifically stated that the student loan debts, these Parent Plus debts and obligations, are marital obligations. They are to essentially be equally shared between the parties. If Ms. Sarah is not going to be submitting any of the payments, if she's going to refuse to submit her half portion of it, my client does not earn sufficient funds. The court has the numbers clearly. My client cannot make that payment. I would ask alternatively that if Ms. Sarah does not make the required payment on this obligation, and the amount is, I believe, I know Mr. Sarah gave me some paperwork on it. I think it was $1,400. if he has to make the $700 payment for his portion and the $700 from Ms. Sarah's portion, he will not have enough money to buy food. So as an alternative to this, I would ask that if she's not going to submit the payment, that Mr. Sarah be given the option to submit the $700 from the spouse board obligation on her behalf. He can submit the payment to those loan agencies in a timely manner, and they won't be in default. Otherwise, we're going to be right back here before the court. So I'm trying to get ahead of a problem that, based on what counsel just stated, I foresee.
Okay. All right. First of all, with regard to defendant's objections, based on Mr. Vernon's statements, and I agree with Mr. Vernon and Mr. Cutler, looking at, first of all, paragraph number 1 regarding the vehicle, I think we all agree that, Mr. Cutler, your language is appropriate as cited under paragraph number 1 of your objection. With regard to the student loans, again, the court would adopt the language that you have proposed under paragraph number 2 of your objection. With regard to the attorney fees, again, the court would adopt the language proposed by Mr. Cutler under paragraph 3. And the typographical errors addressed by Mr. Cutler under paragraph 4. Neither of you referenced the cash surrender issue under the statutory insurance provision of the proposed judgment. Mr. Cutler, you raised that as an issue under paragraph 4 as well. I'm not sure what significance the difference is. To me, reading Mr. Vernon's paragraph, it looks like each side gets their insurance at any value that it might have. So is there a reason why you didn't want that language in there, or you didn't think it was appropriate?
I didn't believe that the court referenced in its ruling any portion to a cash surrender value. I believe it merely stated that each party essentially retains it. When we start getting into cash surrender values, then I start to be concerned as to what are the values and if they're offsetting. I'm just trying to reflect within the final judgment the language of the court.
All right, and I didn't address that. The parties never raised that as an issue for decision by the court or dispute between the two of them. I don't view that as to be an issue that has particular significance here. So I'm not going to require Mr. Vernon to change the language of the statutory insurance provision in his proposed judgment. I do agree with Mr. Cutler that really, from the standpoint of the resources of both parties, these changes will take minimal time and certainly much less time for Mr. Vernon to simply make corrections to the judgment that's already been drafted, as opposed to the time and expense that costs for the defendant to draft up an entirely new judgment. So the court will order Mr. Vernon that you make those changes to the proposed judgment and submit that to the court for signing. In terms of, Mr. Cutler, your issue regarding the student loan debt, I appreciate your efforts in trying to get ahead of that issue. Generally, courts are loath to decide any issues that aren't directly before them. Your motion involved objections to the proposed judgment. The court did not, as Mr. Vernon indicated, order as part of the opinion in an order that Ms. Sarah make payments. And I can foresee that may be an issue that comes forward, but I view your motion much more, your request, Mr. Cutler, as a motion to enforce a judgment of divorce, the provisions of that hasn't been entered yet. So I think while I do appreciate your forethought in addressing an issue that may and perhaps even likely will arise, at this point, I think it's premature. So the court is not making any rulings with regard to that request at this time.
Understood.
That is the ruling of the court as to both motions. That's all I have on this file today, and all parties are free to disconnect at this time.
Your Honor, if I could just ask, when is Mr. Vernon to submit that change? We have a time period, whatever number of days, please?
I would suspect, Mr. Vernon, can you have that within the next 7 to 14 days to the court?
Yes,
Okay.
Thank you.
Your Honor.
Your Honor, Mrs. Sarah has a couple of questions related to the show cause order that she filed, or request that she had filed, so I'm gonna request the court allow her to ask a couple of follow-up questions.
Your Honor,
Okay.
to that, if we could, arguments that have been made, the court's already made a ruling.
It's just for clarification.
Yeah, I'm not changing it. Mr. Cutler, I assure you, I'm not changing anything about, but Ms. Sarah has questions. I'm certainly going to allow her to ask them. So go ahead.
So the March and April car payment, as well as the insurance, will be paid by the defendant, correct?
March.
March. Okay,
Yep.
April due in like 3 days. Am I gonna have payment to pay it?
Yes.
Okay, the pension, I have not received anything. I should have received 2 months already. He gets paid on the first of every month.
Yeah.
And you
Yep.
have
I've ordered that he made both months' payments within the next 14 days to the address that you provided.
Okay, Your Honor, is there any way that the payments can be made through the court so I don't have to deal with this for the rest of my life?
That's something that you can address through Mr. Vernon, but that's not something I can address here today.
And Your Honor, it appears that my client has some response. If likewise, he can be given that opportunity for clarification.
Yeah, if you have questions, Mr. Sarah, that's fine. I'm not going to get into a debate about when you get paid and when you don't get paid. So if you have questions, you can ask a question.
I can't hear you, sir. You're on mute.
I'm sorry, I do, Your Honor. I received a half payment on my pension as of, I received my pension towards the end of the month. And last month it was the 28th or 29th. And I did receive a half pension payment of roughly $925. I myself applied for the Quadra and made many phone calls to make sure the Quadra was in place. So as far as I'm concerned, the Quadra is in place. I do not know why I would get half a pension payment and Mrs. Sarah does not. Ms. Sarah, the plaintiff did not. The other thing I might request is I roughly make $4,000 a month. Paying the plaintiff half of that leaves me $2,000 with a $1,400 over a $1,400 student loan payment, a $660 tax payment, which is marital taxes from 2021. That there is my entire income. I have no more money for another car payment or an insurance payment. I need direction on out of my $2,000, which forget about rent, mortgage, food, utilities. What am I supposed to pay when I only get $2,000 a month? I'd like some direction on what I'm supposed to pay, please.
Mr. Sarah, my job as the judge in this case is to equally divide up marital assets and debts. I've done my best to do that. I didn't live your life for you. I didn't accumulate the debts that you've accumulated. I didn't put you in the position that you're in. So in terms of, I don't have any advice for you about how to live your life and do what you need to do. All I can do is do what I'm required to do, which is to divide up assets and debts as equally as I possibly can. And I've done that. To the extent you disagree with the way I've done that, your remedy is to appeal it. And I encourage you to do that to the extent that you want to get things changed. Otherwise, again, it's not my job to figure out how you're going to live your life. You need to figure that out on your own.
But I'm in an impossible position.
And I guess you put yourself in that impossible position by doing things the way that you've done. And that's not my fault.
not maritally?
So I'm
All
not
right.
going to debate you. That's all I
Okay.
have to say. All
Thank
parties
you.
are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
That also concludes